Hi, so the case that I have chosen today is Cable v. Clemmons Jr. In the Supreme Court of Tennessee at Knoxville. It is volume 36 of the Southwest edition of the Southwest Reporter, third edition, page 39, and it was heard on January 3rd, 2001. So the synopsis says, defendant was convicted in the Circuit Court, Knox County, Bill Swain, of 6 counts of civil contempt for violating order of protection, and defendant appealed. The Court of Appeals affirmed as modified. Upon grant of permission to appeal, the Supreme Court held that convictions did not violate double jeopardy, and trial court had authority to order defendant to attend domestic abuse counseling. So as we begin, the opinion includes the issues. So the issues here are: 1. Whether double jeopardy bars multiple convictions for criminal contempt based on violations of an order of protection, and 2. Whether domestic violence counseling may be imposed as part of the sentence for criminal contempt. So let's get started with the background. So Regina L. Cable and the defendant, Charles Clemmons Jr., lived together and had a minor child. On June 2, 1998, Cable sought an order of protection alleging that Clemmons had threatened to shoot her and had grabbed her hair. She also alleged that Clemmons on prior occasions had pulled a gun and had abused her physically. On the same day, an ex parte order of protection was entered, by which Clemmons was restrained and prohibited from abusing, threatening to abuse, or committing acts of violence upon Cable. On June 11, 1998, following a hearing, the trial court entered a proof of order of protection without social contact. On August 23, 1998, Clemmons was arrested on charges of violating that order of protection. They met up, they telephoned each other and met for dinner. After dinner, Cable declined to spend the night with Clemmons. So Clemmons became angry, grabbed Cable by her hair, and pushed her head against the car window. He then pulled a knife and threatened to kill her. Cable pulled to the side of the road, got out of the car. Clemmons followed her out of the car and then kicked and stabbed the car. Cable fled from the scene and called 911. Clemmons was arrested for violating the order of protection. Clemmons had testified in court about telephoning Cable and going to dinner, but he botched the whole story and acted like he did not grab her hair, strike her, or harm physically. He just said he went home. But the trial court found Clemmons guilty of 6 counts of criminal contempt for violating the order of protection. The trial court sentenced Clemmons to serve 10 days for each conviction to be served consecutively, ordered Clemmons to undergo 45 weeks of domestic violence counseling, and issued a new order of protection. The Court of Appeals held that the trial court erred in finding Clemmons guilty of 6 counts of criminal contempt. The appellate court determined that the underlying acts were so closely related as to time, place, and proximity that they constituted only one violation of the order of protection and therefore supported only one conviction for criminal contempt. The Court of Appeals also held that the trial court lacked the authority to order domestic violence counseling as part of a sentence for criminal contempt counseling and vacated the requirement. Now we are going to analyze the 2 issues. So the first issue was the double jeopardy with the domestic abuse. We begin our analysis by examining the relevant statutory provisions that have been enacted by the legislator to recognize the seriousness of domestic abuse as a crime and to assure that the law provides a victim of domestic abuse with enhanced protection from domestic abuse. So as we scroll down, we see double jeopardy heading. It says we can now turn to the first issue in this case, which is whether Clemmons' multiple convictions for contempt based on his violations of the order of protection violate double jeopardy principles. So double jeopardy protects against 1. A second prosecution after an acquittal, a second prosecution after conviction, and multiple punishments for the same offense, which we will be looking at multiple punishments for the same offense. So the issue here concerns the third, which is what I just said, that is whether Clemmons' multiple convictions for contempt constitute punishment for the same offense under the facts of this case. So applying the first factor of the Denton analysis, which is in State v. Denton right here, they're using that as analytical framework, but the first factor is they observed that only one statute is involved because each conviction was for criminal contempt. Included in the statutory elements of the single contempt statute is the phrase willful disobedience to a lawful court order. The second Denton factor, we find that different evidence was used to establish 3 convictions for violating the order of protection. For example, evidence to establish the first conviction occurred when an argument began and Clemmons grabbed Cable and pushed her head against the car window. The evidence of the second conviction was that Clemmons produced a knife and threatened to kill Cable. Finally, the evidence of the third conviction was that after Cable pulled over and fled from the scene, Clemmons vandalized her car by kicking it and striking it with a knife. With regard to the third Denton factor, we also conclude that although the offenses involved a single victim, they consisted of separate and distinct acts. We therefore conclude that double jeopardy principles do not bar multiple convictions and punishments in this case. So therefore, they do support the multiple convictions and that they cannot use the double jeopardy rule in this case. So now we can move on. We next turn to the issue of whether the trial court has the authority to order counseling for domestic abuse when a defendant has violated an order of protection and has been found guilty of contempt. Civil contempt occurs when a person refuses or fails to comply with a court order and a contempt action is brought to enforce private rights. Criminal contempts, on the other hand, are intended to preserve the power and vindicate the dignity and authority of the law and the court as an organ of society. As we have said, the statutory provisions regarding domestic abuse and orders of protection indicate that violations of an order of protection may be punished as civil or criminal contempt, which I just read the definitions of those above. It is also provided that a judge may assess any person who violates an order of protection with a civil penalty of $50. Although there is no dispute that the court may impose counseling for domestic abuse or substance abuse as part of an order of protection, there is no specific statutory provision authorizing the imposition of counseling as a part of the sentence for contempt. As you can see here, Cable argued on appeal that allowing counseling to be part of an order of protection but not for a violation of an order of protection is illogical and inconsistent with the legislative purpose of addressing domestic abuse. So the court says that we agree that counseling would be logical and potential effective part of a sentence for contempt and that the legislature may wish to consider the issue. We cannot agree, however, that the legislature has specifically provided for counseling as an additional punishment under the present statutory provisions. The trial court's order stated that this is a highly aggravated case and noted that the counseling provisions will be strictly applied against the defendant in the hope he will be able to rehabilitate himself. So therefore, they're adding it to a part of the order of protection and not seeing it as a punishment for it. So in conclusion, it says that we conclude that double jeopardy does not bar Clemmons' multiple convictions for criminal contempt and that the evidence supports 3 convictions in this case. We further hold that although the legislature has not authorized domestic violence counseling as a sentence for criminal contempt, the trial court properly imposed such a requirement as part of a new order of protection. We therefore reverse the judgment of the Court of Appeals and remand the case to the trial court for further proceedings consistent with this opinion. Cost of the appeal are taxed to the appellee, Charles Clemmons Jr., for which execution shall issue if necessary.